Yeah, Baba. Yeah, Baba. It's neat.
Hello, temo femo yo te mi pe mo femo kan bagmene ni femo oyi waladon wa ake ofebe ni mene nwe oba na sanegba ingbeji ni tete obobi ashon ni mi pe bo kan bagmene ni femo oyi waladon wa die nche ngonna wa die nche ake mene wo bakpe mene makane judgment ko ni I release in 2011 Korlewe Wulomo yeli esande ninye inkebu wake the only legitimate Korle Wulomo is Nuumo Okai niji kenkle ni ingbla wo jiami fio ko nkane fio ko achombo age ko shegan traditional council bi ane Korle Wulomo na me ko opt legi Nuumo Okai. Yes, at some point Nuumo aite koblan ameyela womi anokwale nkane na kan wolo habo she amrone ni won you one keji ohye ga traditional council ni obiake namo jimoni ameko opt ni ame recognize ole ake Korle Wulomo abake bo ake Nuumo Okai nkane kote transcript say no ni te no ejeme last week ni assistant registrar ebajepo kote as part of Saleni Nuumo Okai Nuumo aite koblan amenye kote from what I understand I came against somewhere around March na can decision bajepo assistant registrar ni organ traditional council banabile dansale ake yejeme na mojimo na me recognize ole ake Korle Wulomo na mojimo ni ba meetings yejeme ake Korle Wulomo onake Nuumo Okai sanjie na BFA Nuumo Okai jimoni koshegan traditional council ame yosole ne wo gbete ne fe no ba na ni Ga-Mashie ya onake Nuumo Okai efitaye eko ake Korle Wulomo. Now esano no li ake sanene ejenshieche ni in 2011 a judgment ko ye case ne no miniji case be Nuumo aite koblan ke won biye ameti amasama wache Nuumo Okai kelewu won bi judgment na ni makande mabu anytime no ba na ne ake defendant number 7 Nuumo Okai legit defendant number 7 nti mo beni nko abu ne case ne judgment na release in 2011 ni makande mabu no ba abuto Nuumo aite koblan kele won bi ama meji plaintiffs ama meke saniete according to Wolone ni inye. Now lead plaintiff actually ni ayi anan and 5 orders ni defendant say money yo mi lewo actually Egbert tetefio anan and 6 orders. So makane wolu emabu ni some of the things don't know ni ayuo ye mami about Nuumo Okai etomi some of the misconceptions ene jeo ni sempeji ene jeo kenakai ni biyo esa ne yo Wulomo court judgment ne now release in 2011 answer na can question self now boni acho ni ato Wulomo ye Korlewe kani bi fe ene echon fe document ne very very comprehensive 29 pages so mene wa ba kan ni mpi de nche e ba fe ni kan mo so ni no woni ma taking time ni makane de ke document because number 1 miss mo no recognize ake Nuumo Okai legi Korle Wulomo koshe ga traditional council ni okwe judgment ne from 2000. Of course some of the letters in kane abu from ni Nuumo aite koblan release 2016 way after this document I release your court so Nintasha, I was wondering why mine wona aneke wolo judgment in 2011 ni cheme ye no ona amale ke wakutumpo ke wani bi ekome dina kanji mi susumu ekole je na kani ekole reason ko ye no woni cheme ye ne ke 2011 judgment ne ni I release no ona boni nchon ni 2016 amete ni amefe no na me ba fe Nuumo aite koblan ahun kabata 2018 dani a suspendele ye nibi kumami ni ete no ye machine mi ona boni nchon but ke ke judgment in 2011 me wonder why ni traditional council amehe awo mi na me ka tuni ba wo fe be wole no ne wo you and I wole no ne wo wole no ne wo fe wole no ne wo but as far back as 2011 court established the legitimacy of Nuumo Okai as far back as 2011 ne wakemo ko kebu ake Nuumo Okai eje aye kole Wulomo ne je sempe ne esa ne yo kole Wulomo as far as this judgment is concerned it is not true because this document verify yake Nuumo Okai is ejelatokpa mi ni aye kole Wulomo no ke onuna achele papo aken hani bi aye papo e boni achole agbla mi ye kote no ni ewo na achole papo agbla mi boni acho alogbeno na acho na ke wo kole Wulomo ke kole Wulomo beje me mo ni USA sanene ni aye kote e cho wo fe so like I said any ni makane mabwe ani oyosepe ake Nuumo Okai esamoko ni esani atokole Wulomo tomo bemi aka ato Nuumo Okai shimomo nwenwe eba chombo ni document ne yani nkase ni bipi ke bale boni ato Wulomo ye kolewe ona boni nchon ni mi ke bwake ke oko this document ne ni okay compare testimony ni assistant registrar from the traditional council Ebaha last week it clearly tells you okay Nuumo Okai is the legitimate Korle Wulomo. That's just the fact. I'm going by the books. Ke okwe assistant registrar a testimony ne ha ni nkane ha bo nye ni okwe ne ke judgment ne na a release in 2011 it clearly tells you okay Nuumo Okai is the legitimate Korle Wulomo. Ona boni nchon ni tumobeli kebwe Nuumo Okai ye judgment name ye le eke won be they were defendants say amemona asu ame she ame win case you understand what I'm saying many me te asu le ke won che ke himi ani to le ke himi ani support la ke la sane ye Korle Wulomo many me asu ame nam ate court na ke me ame lose Nuumo Okai ke won be mu ame win no documented in makane mabwe now anytime no no defendant number 7 legit Nuumo Okai koni wakwe ni bi ni te no so tashi o fine ni obotwe wa ni wakase boni achon ni atuwa Wulomo ye Korle ni bi ami na achon ke Korle Wulomo bejeme na mo USA na mo fi okusumi ya Korle Wulomo ka ba tole onupa ni yo Korle fe ka ato Wulomo miniji amenuchumo na amechuo document ne e ba gbla mi fe awon nege judgment ne from 2011 e gbla mi fe e hawo ni in fact e hani nkase ni wa e hani le Korle mehu wa de nche ne wo bon ke o town ni okase na kanie then ma advice boake don't go away because it's going to be a lot of reading mene ona boni ncho koni wobotemi ye shiba mi Helen kokoda si real quick ukono bako mimbi nyomo na kokono bako Big Babu Five, Bomade no fe wanyemi you dromo ona. Mene moko send 1,000 Ghana cedis. She unfortunately egbe ba betene na ke majishka lencha kom nya egbe ba. So Big Babu Five, mitani keji oyejeme ofine ni shika ba ogbe ba. So minda boshiwa money o send 1,000 cedis. 1,000 cedis. January 22nd, 2025. Money o send 1,000 cedis. Numo a job wa de nche. Minkpa bo fai bo keji oye ekwe bomode ni okeba onu. Now, our agency to be nkebwe sanene agency 2002 ni I can say ake cheme ni wo numu aite koblan ame ni ame asiu Nuumo Okai ke wonche ye court. Ntumo beni kebwe. Anytime no ba no defendant number 7 I refer to Nuumo Okai. Ni wolone echomi ni bi pi ye kolewe. So anyway jenshi. Now obanake ningma to be kebwe document ka scan onaboni ncho nyele boni fio. So some of the things must struggle for you kekimi. Now in the High Court of Justice Ghana held in Accra on Tuesday the 4th day of November 2011 before His Lordship Honorable Justice K. Amasa Kumsin. I hope I can mean check because it's a little grayed out. Suit number MSC 1006/2002. Nameji plaintiff said ni ayi anan and 5 orders versus Robert Tetefio anan and 6 orders. Now, to be anytime no ba no na refer to defendant number 7 ayo Nuumo Okai sani. It get judgment. Now, but we this suit traveled back and forth through the hierarchy of the superior courts of the land before the commencement of the actual hearing. Ni chake case to be kebwe agency 2002 chomoni bi api mi tebie. The original writ of summons was filed on 9th May 2002. So Jeme shishi Jemi to May 9th 2002 ni neke chemene I'm a filing neke lawsuit against Nuumo Okai ke wonchi. Had 4 reliefs endorsed thereon. After directions have been taken on 31st October 2002, the endorsement was amended on 28th January 2003 to include 3 additional reliefs. Thus, by amended writ of summons and statements of claim, the plaintiffs claimed against the defendants the following. So initially, it was 4 reliefs. Ni me yasu Nuumo Okai wonche amensiki in May 2002. Same in 31st August 2002. 31st October 2002. I endorsed nekeni name ni amechakele eko 28 January 2003. Now make 3 additional reliefs. The original 4 ni ameke ba in 2002. And now, what are the reliefs? I'm a seeker at the initial one. Then I make a come on. A declaration that the purported nomination, election, and confinement of Pakpo Anan, the 7th defendant hearing as the next Korle Wulomo by the defendant is not in accordance with the custom and practice of the Onomroko Korle of Accra, and consequently is null and void and of no effect. So I'm a first relief now. I'm in seek Jake. To any ato anytime nkaba pakpo no na ye me Nuumo Okai abacho any jeni pakpo eje legimo na chon nkaba anytime no ba no defendant number 7 there legimo na refer to. So the first relief now I'm in seek Jake to ni ato Nuumo Okai akeleji Korle Wulomo gbeno na chon na aketole eja no wo court afom yake enye ya no ni eye Korle Wulomo. That is the first relief ni am in seek. Number 2, an order prohibiting the defendants from going ahead to install the 7th defendant as the next Korle Wulomo of Onomroko ake meni me fita Nuumo Okai ye achi amegbe court ekeni ni afo ameno ake ameka ya no ni amefe no na asani amefe ni mo fe mo bae ewomi ake Nuumo Okai leji Korle Wulomo. Number 3, an order of perpetual injunction restraining the 7th defendant from holding himself out and or performing any function as the Korle Wulomo. The 3rd relief jake court a restrain Nuumo Okai ake ekayano ni echue ni ake Korle Wulomo ekayano ni hold ehe ake Korle Wulomo no ekatwe noko ake Korle Wulomo. Number 4, an order of perpetual injunction restraining the defendants by themselves, their servants, agents, and privies from installing from installing and outdooring the 7th defendant as the next Korle Wulomo. Cheme nito Nuumo Okai aka ameka ya no ni amejelepo ake Korle Wulomo ameka ya no ne amefe kusum amecha no na amefe ni bi ne isa na amefe ni mo fe mo ba yosi ake leji kole Wulomo. Number 5, a declaration that the occupation and use by the defendants, especially the 7 defendant and their supporters of house number D403/2 or D477/2 Salaga Market, Accra is illegal. Ake kole we if you make jameji any ball any Nuumo Okai ebata na chu enuchumo ake kole Wulomo ameka relief en wo mi ake court stop ame ni court ha ame egbe ni ameshishi ami ni Nuumo Okai eshishi ami ne kaya no ni echu enuchumo ake kole Wulomo. Number 6, an order for accounts by the defendants of the properties belonging to the plaintiffs in the said house appropriated by the defendant. Ake ameba buakunta yeshia ni ameyo miye ke etase mi ni bi na echufe ake kole Wulomo eba ni eba buye akunta ke che ke ewonche ni tole. Number 7, an order ejecting the defendant and their supporters from the said house. Ake kole we aje Nuumo Okai ke ewonche fe yejeme. So these were the initial reliefs ni Nuumo aite koblan ke ewonche ni tole amen seek from the court. Say these are the reliefs na amen seek initially. No ni ametawo ni court afe eha amejinu. Now, following the amendment, the plaintiffs on 30th February 2003 applied for a second direction in which they set down 3 more issues in addition to the former 5. The defendants on 28th February 2003 also set down 5 additional issues per house in consequence of the amendments introduced by the defendants. The plaintiffs on 30th May 2003 applied for the 3rd time for new directions. These are set out below. Ni agbena semie meni meke sani ete kote 3 February 2003 ameba tao mingbla mu nkome ye kote ni efe na kan Nuumo Okai ke wonche 28 February amwa meke ni bi kome ba fitai ona boni to ni 30th May nwe in 2003 meni ke sani ete say apply for new directions se ko mini jino ni amebio ni kote efe ehame. Whether or not first plaintiff is the acting head of family of the Onomroko Korle of Accra, of which the rest of the plaintiffs are its principal leaders. Number 2, like I said, in document Ebano can say a lot about Korle. So if you really want to know a lot about Korle, especially between Nuumo Okai camp and Nuumo Aite Koblan camp, document piana. Whether or not the appointment of the first plaintiff as the acting head of family was solely for the purpose of overseeing the burial and funeral of the late Korle Wulomo. First plaintiff leji egbe na che Mr. Anan Kenklen ani lele atole act as Onomroko Korle wekunupa alo onabonicho noni jenyo ani to na atole act as Onomroko Korle wokunupa ani atole ni ekwe ni afun Korle Wulomo ni nomie egbu leji Nuumo Aite kobla ni je nyono le egbo ni no se na abato Korle Wulomo konklo ne kesanjine efen ba ani atole act as wokunupa na edumoshi ni afun Korle Wulomo Nuumo Aite kobla ni echon se nope alo eyano ni enye ni eto Wulomo konklu alo awole koni echon wekunupa kayano da. Now, see whether or not the absence of the substantive Korle Wulomo, the gbese manche acts as Korle Wulomo. So a big court nwake court akwani bi amine kwake ani eji anukwali ake keji Korle Wulomo be ani gbese manche ji moni USA lo ke atabi amini abana Korle Wulomo lo nge wolo ne egbele me ani nkane ni BP ni nkase ni BP ya Korle we the way ni ame no yo onabonicho. So this was a question na me biake ani ke Korle Wulomo abe Korle Wulomo ani gbese manche ji moni eyo ese lo. Now, whether or not apart from the 4th and 6th defendants, the rest of their defendants hold any position in the Onomroko Korle, whether or not by custom, the position of Korle rotates between 3 families in the Onomroko Korle. So I may be one kote one kwe ne ekwake ani lela ke keji Korle Wulomo shian ete jino ni yo Korle we ni ani rotator lo ke jebi e baya bi e ke ete bi lo alo shian komepe ni to Korle Wulomo. Whether or not 7 defendant in kebake anytime no ba nu 7 defendant aye Nuumo Okai sandi. Whether or not 7 defendant is customarily qualified to be installed as Korle Wulomo. I mean, big court, any court, and in Nuumo Okai, and you qualify your ake as a sani atole Korle Wulomo. Whether or not the election and installation of the Korle Wulomo is done by the acting head of the Onomroko Korle in consultation with the principal elders of the family. And if so, abiake ani keji abato Korle Wulomo ani Onomroko Korle weku ichwe eke weku iche konklome tashi ni amefio dwemo chomo ameba dwemo chomo ke gbe pamo ni ayano ni ato Wulomo lo alole kometo ebanye edumushi ni eto Wulomo. Whether or not the appointment or installation of the 7 defendant by the defendant is sanctioned by custom ni akwake anito ni ato Nuumo Okai ani eji kusum na alo kusum benalo alo achon kusum bena na keto Nuumo Okai lo. Whether or not house number D408/2 or D477/2 Salaga Market, Accra, had been built long before the birth of Ni Tete Kwe Molai abiake ani Ni Tete Kwe Molai ani Tony ani shia ni yo Salaga ni ji Korle we any wole ne yo ani abiake na kan shia wache Ni Tete Kwe Molai le emashia alo ato nakan shia omo from what I understand Ni Tete Kwe Molai ni Nuumo Okai leji a great grandfather. So Ni Tete Kwe Molai Nuumo Okai leji a great grandfather. Now abiake ani leji moni e machine alo a machine omo before afole. Whether or not the registration of the said house in the name of the said Ni Tete Kwe Molai was made merely for administrative convenience. Ake anishia keji shia moni gbe mi ni eyo ji Ni Tete Kwe Molai ani ake wo egbe mi keke just for administrative purposes alo shia leji moni ema. Whether or not the defendants have broken into rooms of the said house and unlawfully appropriated properties belonging to the plaintiffs. So abiake ani many mena sama menefe including Nuumo Okai ani amedwa kewo chuye kome ni yo Korle we lo ni amelolo ni bi kome ni many me asama mene ama amenomilo. Now whether or not the defendants with the assistance of hired thugs are preventing the plaintiffs from entering the said house. Court to akwake ani meni mena asu amene ani ame haime ni ame pene ni plaintiffs ni ji meni me asu na me ba na egbe ke ba shi amelo. Now but we again the defendants set down as many as 9 additional issues, all of which were struck out as taken care of by the issues set out by the plaintiffs. So actually what the defendant say I'm only be ni ametawo na me be ni amekeba je strike na can be out because it is not any different from noni plaintiff say many make sani e court kete court it is not any different from noni amekeba ona bonincho so je ke like noni nyeyu ke wadumo noni many me basu e keba ni we decide no e ba mo sani na e ba answer any question say so eyan ni mangmenye gbani nyu nyeke ni bi ko ma wo mi. Now, but their main ground was that the nomination, election, and installation of the Korle Wulomo was a cause of matter affecting chieftaincy. In his ruling delivered on 23rd July 2002, Asari Koran GJA, sitting as an additional High Court judge, dismissed the application on the grounds that the Korle Wulomo was not a chief within the definition of the word as the Chieftaincy Act 1970, Act 370. Dissatisfied with the ruling, that is, the defendant, instead of appealing against same, reported to yet another application to set aside the writ and service thereof on virtually the same grounds. The inherent jurisdiction of the court were thrown in for good measure. This second application was on 25th November 2002, again dismissed by Mrs. Agnes Georgie J, as she then was as misconceived. Believing that their objections to the suit had been erroneously overruled, the defendants resorted to the Supreme Court for redress. In March 2003, they applied to the Supreme Court for an order of certiorari na word ojugba. Either certiorari or certiorari, to quash the ruling of the High Court dated 23rd July 2002 as being null and void under its inherent jurisdiction, and again to dismiss the suit for want of jurisdiction. Eventually, this application too suffered a similar fate as those before it. It was dismissed on 17th March 2004 by Mrs. Cecilia Hansi Soa J. On 16th June 2003, the issue for trial were finally settled in the summons for direction. So in June 2003, after the defense actual in 2003, finally Sanye Eshe Yeli Mobi ni Aboin Sanye Yeli. Now the court dates for the day as recorded read funny keke me feel ball a little faint in keke me screen and na boni screen yo. Now the issue as raised by the summons for directions filed by the plaintiffs take care of all additional issues. Issues 6 and 7 were raised in preliminary arguments and had already been determined by this court. The court therefore would not set down these same issues for determination. The additional issues are not necessary. The issues set down by plaintiff will be the issues for trial. The additional issues are hereby struck out. So nibi ya komeni akefita ife jeje ejefe yemi koni anye ayano ni ayesanie. Now, although the record shows that the defendants appealed to the courts of appeal on 27 June 2003 against the decision to strike out the additional issue, there is no information on record that the appeal was pursued. The above is by way of appreciating the background of the case and the rough terrain the suit has traveled up to the opening of the trial proper on 6th July 2004. So any our background there koni wana no ni sani chomi nibi ni both parties star work and nibi ke any sani ja appeals can nibi na ke womi can nibi amendments ni plaintiff self file can nibi jeje any wana li ake ke any me fe womi koni wana how ni sani travel through the court keba she any keba shene ona boni chon. Finally, trial started 6th July 2004. Now, I will at this stage state the relevant facts as pleaded by the parties. According to the Sobiane Judge Lene Kalagbene Chononi plaintiff say I'm a Sanie Boni I'm a Jajele. You're no fair no me. Both way. According to the plaintiffs, the first plaintiff is the acting head of Onomroko Korle, and the other plaintiffs are principal elders of the said family. So I may many I may assume I may kesani te kote I may chono wake plaintiff number 1 Mr. Ananede Nyame ye Beleji Onomrako Korle wekuicho ni menifita na ya siwe ameji weku nupai nifita le ehe. They admit in their pleadings the defendants are also members of the family, but they hold no positions. So I may admit that many amekete kote ameje Onomroko Korle shimon onukpa ni yo Onomroko Korle we amefitai. Now, following the death of Nuumo Okai Kobla, so agbene nyanya wo buato e nke na ba no kase ni bi pi e Korle we ame Wulomo to keni bi ke Sunday no ni back and oba boto ojugba. I mean many ni no chumo ni min kan and it's like wow, this document is really good and detailed. Sometimes I can ona judgment instead of summary ni ona body chon e have any about very detailed. I really enjoyed reading this. Now, following the death of Nuumo Okai Kobla II in 1995, the traditional office of Korle Wulomo, which plaintiffs contend rotates between three families in the Onomroko Korle way, became vacant. So I mean chono kwake ni Nuumo Kobla ni jienyo egbo in 1995 plaintiffs say I mean sister ke Korle way shian ete ni atoa Wulomo ekejo. So far ni egbo 95 atoko mokodon. By custom, the nomination, election, and installation of Korle Wulomo is done at a meeting summoned for that purpose by the family head and attended by all the family elders. So, achono kwake kejibe shena sana to Korle Wulomo. Weku ichwe echo weku nukpa efe na me batashi keke ame susu keke ame pai keke ame take decision as to the way ni ame bayale. The plaintiffs allege that contrary to the accepted customary practice, the defendants, without the knowledge and consent of the plaintiffs, quietly and surreptitiously, nominated, elected, and confined the 7th defendant in preparation for his installation as the next Korle Wulomo to succeed ni Okai Kobla II. So I mean, chono gwake ni. Mind you, Nuumo Okai Kobla ni jienyo egbo 95. No, amenchono waka ye woku emie, esani woku nukpa, eche woku mefe, ne ka maba na tashi, na amefe, ame kwa the way na ame bayale. Shi, ni ame bato Nuumo Okai woku nukpa che, woku iche konklome ni fite ye, ni ame batashi na mbafe. Shi ame dienche, ni ame mumu ame no, ni ame mokole Nuumo Okai, na ame wole chumi. Ni ame chukusumi hale na ame fele Wulomo no meni meke sani ete echiake jena kenjim la esani weku ichwe echa weku mefe ni atashi ni adwen shina to Nuumo Okai ame fe na kai ame momo ame no ni ame wole chumi na ame fe kusumi hale na ame tole Wulomo na kanjino ni meni ke sani ete na kanjino ni ame yue. Now, the plaintiff contended 7 defendant is not customarily qualified for that position by means of not being a member of any of the eligible families. So in Kabak anytime no banu 7 defendant Nuumo Okai. So no ko na me we jacket Nuumo Okai e qualify because weku ete ni atwa Korle Wulomo yemie Nuumo Okai eje ne ke weku ete name le wo anye ni atole Wulomo alo esani abatole Wulomo na kanji no ko ni ame allergy. They further contend that Ostoma D402/2 or D477/2 Salaga Market, Accra, was built by the plaintiffs as the family house of the Onomroko Korle, where a lawfully elected Korle Wulomo and his family reside. Ake Korle weni wale ne yo sla jeme weku enima boni afenika ato Korle Wulomo nile ke weku me ayin jeme. Now, defendants have unlawfully occupied the said house, broken into the rooms, and unlawfully appropriated properties to the plaintiffs, and with the assistance of hired thugs, prevented the plaintiffs access to the house. Nuumo kanka ye watch ni tole ameke tax wako like land guards eba ni ame mena ma siwe amena egbe ni ame ba shiami agbene nwe ame dushi na ame dura ishi na ji na ame te chu inkoma mi ni ame juju ni bi ikome ni meni ke sande ne te ne ameke amame no allegation ni ameke fun Nuumo Okai ke e wonche ne so fe yemi ni aye. Now, on the part of the defendants, they all claim to hold positions in the family. either as office holders or principal members. They deny that Korle Wulomo rotates among 3 families. So, defendant say, "Niji Nuumo Okai ke one chair na sue ame." Miniji ame na GMO keneka allegations na the plaintiff say here. Ame nchono gwake. Ame we Korle we bi ji ame. Ni je Korle we bi keke pe ji ame. Show nukpa ji ame ye Korle we. Agbene we ye boni ame lele ke boni ame bani na le abehia yete ni awo Korle Wulomo ejeme. Korle we ekobeni ni ato ke be hye na ba ato Wulomo ke ka ato hye abehia yete ni ke jebi e ba ya bi e ke te bi e no ni defendants ame call ne agbene no jino. Now, as far as the defendants are concerned, the first plaintiff at some point acted as head of family for the sole purpose of supervising the burial and funeral of Nuumo Okai II. They further pleaded that by custom and tradition, the Gbese Manche answer again question about the Gbese Manche acts as Korle Wulomo in the absence of a substantive Korle Wulomo. In respect to the 7 defendants, they pleaded that his nomination, election, and confinement were all done in accordance with customs. So I'm a defendant. I'm in Chono Gwake. First plaintiff, money enye Nuumo Okai kobla ke na kanji boni makele ke wambia na amete ama asiwe million. Money many nyame ye ni amete ama asiwe million. Ni amete ama asiwe miye many nye keneke sanene te kote onukpa ni nye lele atole ake eba ye wekunukpa shi wekunukpa na atole koni ekwe ni afu Nuumo Okai kobla ni egbo pe atole ne eba ye wekunukpa in perpetuity ka tabi amine eba agbo shi atole ni Wulomo egbo ani di mokone ba nye weku eyi na afe yala no na wola ka acti koni akwe ni afu Nuumo agbene we ya mesusu mo mi we Nuumo Okai gbeno na mecho ni ameke selectile ni amekele wochumi ni amehani afe kusumi hale eji be papa no echom lano. Now, regarding House number D408/2, the defendants denied plaintiff assertion and averted that it has always been in the name of Nitete Kwe Molai, grandfather of second defendant. Ake nakenshia na chon Nitete Kwe Molai le eshiani. Now, the first plaintiff testified on July 6, 2004. So be ane sanie agency botwe. As pleaded, he claimed to be the head of family of Onomroko Korle with the other plaintiffs holding positions in the family. He admitted to knowing the first to 6 defendants, but denied they hold any positions in the family. He stated that the 7th defendant was not a member of the family and that he, the 7th defendant, comes from Sempe. So Ajeshi. So first defendant first plaintiff many kesani ete money nyenye eke anukwale leji Korle Wulomo weku icho agbene we defendant say from number 1 to number 6 say Eliame Korle we bi ji ame Shimon Eliame ake ame ye any position first defendant when we ni ayi anan leji first defendant ni ayo she ele ake 1 to 6 onukpa ni fita ye weku nukpa iji ame ye Korle we agbene 7 defendant niji Nuumo Okai na tole eje Korle we she eje Sempe nakanji noni ne bata se mi na to na sane nakanji no na ewie. Now, on the custom for the appointment of a successor Wulomo, he testified that he, as the head of family, convenes a meeting of the heads of family to select a successor. The defendants, not being elders, are not eligible to be invited to such a meeting to consider the selection of a Wulomo. They are also not entitled to select a successor Wulomo. According to him, a successor Wulomo must trace his lineage patrilineally and must of necessity come from Korle. So egbra mi ake niji amache egbe ko mabo niji ni ayi anan niji ni ayi anan na enye meni meke sanene te kota yin egbra mi ake onukpa eni fita Nuumo Okai ye je Korle we onukpa iji ame no akeni je Korle we onukpa iji ame keji afekpe ko ni akbawo Wulomo eko ame eko eyin ake abache ame kebami agbene nwe ke abatobo Korle Wulomo esani ochese je Korle we ke abatobo Korle Wulomo esani ochese je Korle we ni ame aleja ke Nuumo Okai echese eje Korle we no wo esani atole Korle Wulomo. Now the plaintiffs deny that Ga-Mashie acts in the absence of Korle Wulomo, although they admit there was a dispute between the Ga-Mashie and the Korle. They dispute the defendant assertion that the dispute was resolved and the Ga-Mashie resumed his role as acting Korle Wulomo. The plaintiffs contend that it is not the tradition that the kingmakers appoint the Wulomo, and that it is not true that the Wulomo is put on the lap of the Ga-Mashie. According to the plaintiffs, the sanction of the installation of the Wulomo by the Sakumo Nae Wulomo and Ga-Mashie is not customary. And if they did so in the case of the 7 defendant, then it was done out of ignorance. So e chono kwake eje anukwale ake keji Korle Wulomo be Ga-Mashie jimoni eyo enajian eji sane ni court ba decide whether leleke Korle Wulomo be Ga-Mashie yo enajian lo court ba decide. Now also ame awomi ake Korle Wulomo ke Ga-Mashie at the time sane ye shimo keji Nuumo Okai ke wonche ke na kan sane akwena asa eje anukwale asako na kan sane agbene keji ato Korle Wulomo akele ta Ga-Mashie sure no ni je nyon agbene we keji Nuumo Sakumo Nae Wulomo ke Ga-Mashie eba fe kusumi ale ka to Korle Wulomo na kanoko ya no keji afe na kan eja. According to the plaintiffs, the sanction of the installation of the Wulomo by the Sakumo Nae Wulomo and Ga-Mashie is not customary. Eni twanke ebe kusumi. Now, on the existence of the 2 traditional offices of Ga-Mashie and Agbache, the plaintiffs dispute that they exist in Korle or that the defendants hold those positions. Now, 2 positions come here ni no awe e come ji Ga-Mashie ke come ji Agbache nye nke bo aka ke mi ake Korle Agbache ji moni to Wulomo je Ga-Mashie amenchono gwa ke ye Korle ada positions ko ni achola Agbache ke Ga-Mashie no wo meni me ime ko meni fita Nuumo Okai ni mokome ke Agbache jile mokome ke Ga-Mashie jile na kan positions be Korle so no na me you ebe wolomi. Now regarding house number D402/2 or D477/2, the plaintiffs contend it is the Onomroko family. It was the Onomroko family built by Odai Into. They contend that there are 2 houses, Onomroko Way and Korle Way, in the same area. According to the first plaintiff, the 3 heads who elect the Wulomo are to occupy the house. The plaintiffs are virtually being chased out of the house by the defendant. So I mean chono kwa kene keshi ane na chone je Nuumo tete kwe mola inchele ojugba obana gbe ko nima shimo Odai Into jimoni manekeshi ane ni ameweku iche ni yo Korle ameni esani ame inekeshi ane amenchono ko nwake solo Onomroko ni solo Korle Onomroko ke Korle shine shorte enyoni na kanjino ni plaintiff say eke ni ameni enja ameshia ni ameche Odai Into ma eha me abashua me yemi. Now, plaintiffs deny that the house has ever been in the name of Tetekwe Molai Naganon Chele, as claimed by the defendants. Ake shia yame ye ame susum kebona amelele ame Nuumo Odai Into leji monima je Tetekwe Molai ni emashia. Now, The fourth plaintiff. So any plaintiff say I'm a testimony say can be a son ne ka gbe na keke acha no. The fourth plaintiff testified that he knew the defendants and that they hail from Sempe and not Onomroko. In Kebaka, look, I'm a man, I'm a sani ete, I'm a dench, I'm a nifemo, and I was sani a chafo because I'm a fan, I'm a nabu bekome, I'm a yes and solo, mene kele, but stand there, no, I'm a man, I'm a sani a monte, so come away. First plaintiff and abile sani, eke many metalashie, J. Korle we be jiame. Now, the fourth plaintiff, he knew the defendants and that they hail from Sempe and not Korle. She amameje Sempe, she mo ameje Onomroko. According to him, first defendant's father, Okai Anan, who became the secretary in Korle, hailed from Sempe. He also denied the existence of kingmaker at Korle. He, however, considered that the first plaintiff, that did not take part in the installation of Nuumo Okai Koblan. So plaintiff first why you no conclude menele weba e chake ni yen few now but we. Now the first and third defendants testified on behalf of the defendants. So I'm a defendant say ni ashame no. Mind you, defendant number 7 leji Nuumo Okai minsa. Defendant number 1 egbeji Hegbert Tetefio Anan legimony defendant number 3. I'm a testify on the entire defendant say Niyo case say no. They contended that in Korle there is no head of family and that it is the Wulomo who occupies the office. So ame chono keke Korle awo we kuicho yegeme Korle Wulomo ka ekoye legimony efio mini eyo we kuicho. Now but we first defendant testified to his parental background and the positions or the other defendants of the other defendants as well. My father, called Judge Okai Anan, hails from Korle. Second defendant is my father's brother. Is my father's brother's son. That is a cousin. He hails from Korle and is the Korle Jaseche. The third defendant is from Korle and is the Korle Agbache. The fourth defendant is the Korle Wayo, i.e. fetish priestess. Fifth defendant is the Sakumo Wulomo. Sixth defendant is a senior priestess of Korle, and the seventh defendant is his son. So I'm a defendant and I'm a get what fair what you Korle minche. Eje Korle eye secretary Korle down. I'm a fair me tro na meje mene leji Korle you. So take your take je Korle na toile Korle you. Mene onum so chono kwa ge gba chon position mene leji Korle jaseche mene leji Korle agbache ka me je Korle take your take na to amene ke ni bi fin but defendant say in can plaintiff say no ya bombo defendant say no ni eba ni ameyu one now but we first defendant's mother, Hannah Aku Alote Brown, hails from Sempe. First defendant has two brothers, Christian. So on any Sempe by me. So you said Sempe first defendant Eliji Egbert Tetefio Ana le emami nije Sempe. She papa le Korle we GNJ. So on a Sempe link now but we first defendant has two brothers, Christiana Aya Mensa Anan and Edmond and Christiana achon Christiana again first defendant has two brothers Christiana alekole Christian more is a typo Christian Aya Mensa Anan and Edmond Adu Anan and their names evidence their origins as coming from Korle. He entered exhibits 1A 1B his baptismal certificate and those of his brothers bearing the name of his parents to prove that he is from Korle. Other children of the first defendants are Ni Okai and Ni Adu. The seventh defendant, son of the first defendant, bears the name Pakpo. I'm going to go to Pakpo na chole. Oh, okay. So Nuumo Okai papa G first defendant eleji money assume. So now any kpakpo eje agblami no na keke amemfe na kpakpo ni kpakpo so boni any kpakpo eje to si eche echono wege le je kole we le mami ji moni je sempe ona she papa le kole we eje le ji egbetete fi wana no ache le ji first defendant. So again, the seventh defendant, son of the first defendant, bears the name Kpakpo, a name admittedly not from Korlewe. First defendant, however, explained that the name Kpakpo was borrowed at the request of his mother, and the necessary customary rites were performed to evidence that fact. So the Kpakpo akawole because ena ni eba ake abagbe na akewole eke first defendants right ama kan eje me ko eke the seventh defendant, son of the first defendant, bears the name Kpakpo, a name admittedly not from Korlewe. First defendant, however, explained that the name Kpakpo was borrowed at the request of his mother, and the necessary customary rites were performed to evidence that fact. So, le Nuumo Okai ena nike esumo ni awo enabile ena ni if I sorry you ena ni kake esumo ake awo ebile Kpakpo because ena ejesempe ona boni nchon no jino ni ame ani wole eni Kpakpo eje min paje 5 you iba it is Saturday. Okay, here we go. Here we go. Ora, so ena jimoni eje sempe nile efa ake esumo ake na kengbe awo ena bile newo aba afe kusumi ni akeba gbe Kpakpo ni akewole onu shishi. Now the third defendant testified that the third plaintiff was his brother from the same father. Ona yibi na ma wo yemi. So mind you, ake plaintiff say fe ka ake si amele Nuumo Okai papa kay wonche family ame na metemo komoko eje Korlewe. See defendant number 3 kake third plaintiff inyamini wo fe chekomeni forward. So tef your 10 mene ame ona kutumbo ka amale wo ene chebino kake lele yeko kwa ganambe echebi ye solo me mami si chebi ji ame he does not know the 4th to 6th plaintiffs. According to him, the second defendant is his cousin, their fathers being brothers, and that he, a third defendant, holds the office of Agbache. So Agbache kake a third plaintiff solo mo. Now, the fourth defendant, who is the fetish priestess of Korlewe, is the senior brother's daughter. He corroborated that the fifth defendant is the Sakumo Wulomo. So nyeme so na shekote aye anukwale. Mini fe wakandangbe. Nyeme so nekeno kone wa because mesumo na yanukwale nyemi nkake ele nyemi. No mo no pe wa ye. No mo no pe wa ye. Now, Vanami, 1 second. He testified that in the absence of a Wulomo, the Ga-Mashie acts as such and would, in the event of vacancies in the Ga-Mashie and Agbache positions request. Okay. He contends that in the absence of a Wulomo, the Ga-Mashie acts as such and would, in the event of vacancies in the Jase and Agbache positions, request the appropriate house, that is the children, those office holders, the children of those office holders, to appoint replacements and then consult to appoint a Wulomo. So achono keji abekole Wulomo gbese manche jimoni echuo kole Wulomo nuchumo ni keji bebashe ni jaseche alo agbache be gbese manche ani jaseche ke agbache ne amebi fa moni esani ameba ye amenajiami keke ekame epai keke ato kole Wulomo. Thus, initial proceedings was followed in the appointment of the herein 7 defendant. After the children have made appointments to fill the Agbache excuse me, and Jase positions, they informed the Gbese Manche to come to perform the necessary customary rites. These procedures were followed in the instant case. No what? I mean, chono gwake kaba to kole Wulomo. Nekeji boni yale ni nakengbeno pepepe ni excuse me aketo Nuumo Okai. Mene ya nuchumo ngena nu eko nyonsem ye ibo informo aba transfer to mo gbege bibio. Now, after these customary rites, the Agbache and Jaseche sit together with the fetish priestess, and an oracle is consulted to tell them who to be appointed Wulomo. No wakeji afe ne kendi bi ne fe gbese manche ke Agbache ke Jaseche tashie. Ana wayo ni wayo cho one ni a consultole be abio wo gbejiano to alo ejomo chomo alo moni le sumo ni atole Wulomo ni echono gwake nekeno kwe achomi mfe ni aketo Nuumo Okai ake leji kole Wulomo. After the oracle has given the necessary directions as to where to choose the next Wulomo, money and drinks are sent to Sakuma Wulomo, Nae Wulomo, to inform them that a Wulomo would be installed within a week. This is to get them to hold themselves in readiness to perform their customary duties at the installation. They then select 6 to 10 strong men to go and capture the chosen Wulomo. Nuumo Okai le picture your screen there no legit the legitimate Kole Wulomo. Nuumo Okai legit the legitimate Kole Wulomo. Now, so I mean chono keji afe na emefe na consult one ni watch on money awole Wulomo keke bo Nuumo Sakumo kena Wulomo amanie ka aka ma ke ye ochima mi abato Wulomo keke afa oblahi ni ami kankalo ni ame dala na me ye wale ka mete ame awo Kole Wulomo. After the capture, some special leaves are put around his neck and shouts of Neo, Neo amidst pomp and pageantry. When the Wulomo is brought to the house, a goat is slaughtered and its blood poured on his feet. He is then confined in a room to be with the fetish priestess. No wakeji afeneke ni ayamole keba keke afoto eke onagen keba kene chombo kusumi efe. It is very very interesting reading this document. Ake kote capture every single thing. This is a very comprehensive judgment. Ke afoto ashweno ke afoto ashwena no ke awole chumi ke woyoe. On the day of the capture and confinement of the Wulomo, word is sent to the Gbese Manche, Nae Wulomo and Sakuma Wulomo, who also sent emissaries to come and ascertain the information for themselves. And achono ke kag benape eke achume keke abo Gbese Manche amanie abo Nae Wulomo amanie abo Sakuma Wulomo amanie ke amomoko ni akele ewochumi. Around 10 p.m. achono ganagangwile gbeke 10 p.m. in the night, the Nae Wulomo and Sakuma Wulomo would come to the house to see the chosen Wulomo and teach him the do's and don'ts of his office and leave around 2 a.m. This ritual continues for 3 days. No work bini ababo Nae Wulomo ke Sakuma Wulomo ake womomo wakele wochumie catch a beke tene ameba ni ameba chole nibi ni esani wulomo efe ke nibi ni esani efio aba chole kusumi efe amefio na kan fogbiete. On the third day, the Wulomo is dressed in white calico. The Agbache sits him on the lap of the Ga-Mashie 3 times, and the Ga-Mashie in turn sits him on the Korle stool 3 times. After this, the Besemanche will come and greet or congratulate him, followed by the Sakuma Wulomo and all the Wulome and chiefs assembled. Finally, he is given a stool name. No wake agbena binije teke ajele echuemie keke akeklala yen ewole eke agbache ekeleta Ga-Mashie shuono shiete Ga-Mashie le uba choi ekele Korle Wulomo eta seyeno shiete ke agbena Besemanche baba ni ebeba congratulate le eke no se Sakuma Wulomo ke majianche me ke Wulome konklo me ni ba je me fe amefe me baba ni ameba congratulate le no se dani abahale esen be. Third defendant testified on oath that he lived with the last Wulomo in the Onomroko house for over 30 years. His father, Tetekwe de Agbache, and stood Nuumo Okai the second, the last Wulomo. So third defendant, Nuumo Okai ni jenyo ne gbone ni aba eseto ni sanede bade. Ekrei Onomroko fe more than 30 years. Afi nyumai ete ni leche le eye Agbache ni echeji moni eto Nuumo Okai so na ke bi confirm onye no ni nke egbe na ka ke Korle we Agbache jimoni to Wulomo mene echonu kwa ke le eche ake Agbache le jimoni eto Nuumo Okai ni jenyo Wulomo ni egbo dani abashe biene. If I need to me show Google me. Sorry, excuse me. The witness testified that Nuumo Okai II was put on the laps of the then Ga-Mashie, James Ashong Ayite, the father of the second defendant. He testified to how he and the second defendant were appointed Agbache and Ga-Mashie respectively by their family. So Ga-Mashie ke Agbache ne ba me cheme ye koda no na me cheme twa me se ni akeha me ni ameba amenyene. Now bono ni jeje yue bie. The significance of the testimony of the third defendant is that the 7th defendant Niji Nuumo Okai means Nuumo Okai means Nuumo Okai, let's keep it like that. Nuumo Okai is customarily qualified to be appointed a Korle Wulomo, and that all the customary rights and practices pertaining to his nomination, election, confinement, and installation were duly performed. In respect of house number D402/2, third defendant stated that it belonged to his grandfather, Ni Tetekwe Molai. It was in that house that his father and aunt were all born and lived. According to him, the second and third defendants were all born in the same house. His brothers, Ayite and Aya, sisters, Tete and Tetele, were all born in the house. The third defendant further testified that the gang custom testified that by gang custom, the deceased are laid in state in their paternal house, and in accordance with the custom, the following close relations were laid in state in the house: Tetekwe Molai, grandfather, Kokhoi aunt in 1959, Tete Mercy, sister, Aya Kwe, brother, Obolo Akua, fourth defendant and daughter. Echono kwa kedwa mene me fe na me gboe amechese ji Korle we no jameji eni akamengme. Now, from the evidence, let the following facts stand undisputed. So jeje nchono kwa ke evidence ni akefe ba court emie eyane anake nekeni bi neni wo ba yue ne eji anukwale now both way. Ni Aite Koblan II was the last Korle Wulomo. That is number one. Number two, a Wulomo must of necessity come from Korlewe and must trace his lineage patrilineally in the Korlewe. There was a dispute between the Ga-Mashie and Korlewe. The point of dispute is that while the defendants claim the dispute has been resolved, the plaintiffs allege the contrary. Where there is a substantive Wulomo, it is he who heads the family. The fourth and fifth defendants hold offices in the family and live in house number D40H/2 as of right. Finally, the father of the first defendant was once secretary to the Korlewe family. Plaintiffs, however, claim he was from Sempe. And whether or not first plaintiff was appointed by acting of the family for the sole purpose of overseeing the burial and funeral of Ni Aite Koblan II. Now, the plaintiffs pleaded that first plaintiff is the acting head of family of Onomroko Korle. Onomroko Korle first go make I got solo Korle. And that the other plaintiffs are principal elders of the said family of the other plaintiffs. All that the first plaintiff said in his evidence in chief was that the second plaintiff was deceased and that the other plaintiffs owed positions in the family. Without giving any details, he said they help him to perform customary rites in the family. In respect of his own capacity as head of family, this was his brief testimony. It is not true that the Ga-Mashie acts in the absence of Korle Wulomo. There was a dispute between Ga-Mashie and Korle Wulomo. I was asked to supervise the burial of the Wulomo and see to the installation of the next Wulomo. The dispute with the Ga-Mashie has not been resolved. The defendants disputed the capacity of first plaintiff as head of family, contending that the Wulomo is the head of family in Korlewe and that in his absence, the Ga-Mashie acts until a substantive Wulomo is appointed. Now, Bobby, excuse me. Since the defendants disputed the capacity of the first plaintiff, the latter bore the burden of proving his capacity. To discharge that burden, he tendered Exhibit A, an invitation letter dated 28th April 1998 from the Korlewe Youth Association, addressed to Mr. Peter Ala Ajete of Okante Chambers. The invitation letter signed by one E.A. Annan, secretary to the Korlewe Youth Association, attached a resolution of the youth appointing first plaintiff as acting head of Korlewe to take up the duties of the late Wulomo till a substantive Korle priest was installed. So, defendant say, J. Leji, atole acting head there, Koni ekwe ni afun Korle Wulomo pe na egbo she ame wola ke eye tumobedi nke ebo head of family kecha no now so be esane prove no e ke no go ba mi e ke letter ko ba ni no chon ake in 1998 Korlewe Youth Association ame ma letter ke ame lawyer Peter Alajete ake ame sumo ni ato the first plaintiff atole Korlewe Wulomo Korlemo wekuricho poni ekwe ni afun Korle Wulomo ni egbo. Now, the relevant paragraph of Exhibit A reads, "We are again by this letter inviting you to Korlewe on 1st May 1998 to witness the appointing of Mr. Ayi Annan as the acting head of Korlewe at 9 a.m. The first two paragraphs of Exhibit A, the attached resolution, are relevant and will be reproduced for effect. It reads, at a meeting held at Ashoma in the premises of Mr. J.A. Annan by members of the family of Korlewe clan, it was resolved that a funeral committee be formed to see to the burial and funeral of Nuumo Okai II, the late Korle Wulomo, who died on the 9th September 1997. Statement of claim says 1995, which is wrong. However, it was unanimously agreed that Mr. Ayi Anan be appointed acting head of Korle to take up the duties of the late Wulomo till a substantive Korle priest is installed. It is clear from Exhibits A and A1 that the first plaintiff was appointed by the youth of Korle for the limited purpose of performing the duties of the Wulomo and overseeing the burial and funeral of the deceased Nuumo Okai II and the installation of a successor. So no achono gwake awole limited pe boni afe ni ekwe ni afu Nuumo eko ni ekwe ni ato Wulomo konklu. In disputing the claim of the plaintiffs, the defendants denied the existence of head of family in Korle. They contend that it is the Wulomo who is the head of family, and when he is absent, the Ga-Mashie looks after the household either by himself or appoints somebody to act on his behalf. This the plaintiffs deny. The significance of the defendant's argument is that the appointment of the first plaintiff by the youth was both uncustomary and unnecessary, as the Ga-Mashie was available to perform the role assigned to the first plaintiffs. So I'm in chono kwake Korle youth I'm a baby ni esani ame mawolo ni ameke select moko ni eba acti as ame wekuicho eja ake ye defendant a susumomie keji Korle Wulomo be Ga-Mashie jiboni eyo enajiam. The plaintiffs categorically dispute the fact that the Ga-Mashie acts in the absence of Korle Wulomo. So plaintiffs say they contend that the Ga-Mashie is a chief and cannot be a Wulomo. This is how first plaintiff addressed the issue under cross-examination. Anyway, ke sakuma Wulomo be Ga-Mashie ni USA. Ga-Mashie by nature abeje Wulomo ni. Shike sakuma Wulomo be Ga-Mashie ji money a performer e kusumi mfene a performer. So ke Ga-Mashie ke Korle Wulomo be le USA, it is not that far-fetched. I'm just saying. But court bani wanna answer self. Now, question. Be an agbene abi plaintiff says under cross-examination. So the defendant say a lawyer ni eba ni ebio plaintiff first plaintiff money legi acting buku icho at the time and I can just say kwena funumwe now. By tradition and culture, the Wulomo is the head. Answer ne when the Wulomo is alive, he is the head. In his absence, a head has to be installed. So leke dabi ke Wulomo tashiye leji Korle we fe we kuicho. Shimo keji ebe esani atomoku ni echu we kuicho nuchumo. Because there is no head in the absence of a Wulomo, that is why Ga-Mashie looks after the household. So ke Wulomo be Ga-Mashie ji money esani eye najan. E answer eke dabi eje anukwale. The fourth plaintiff, on the other hand, testified on the subject under cross-examination as follows. So both way, in cannot me take court, I'm sure me yashi. Because I mean now me fair come na me kesani take court. Come me you no conclude, come me ba you no go. So mind you, first plaintiff niji Mr. Ayi Anan. Mr. Ayi Anan, first plaintiff nye. Excuse me. First plaintiff ni enye Mr. Ayi Anan bona. Le ekake ke Korle Wulomo be je Ga-Mashie USA. Awu omoko ni mo yu na jan ke atabia mi na ba to Wulomo konklu. Fourth plaintiff ne fita me no am group me no. Fourth plaintiff na bi lesane komune ne ke. Korle traditionally has no head of family. A answer, they have a family head, which is the Wulomo. Question. So the Wulomo is the only head of Korle. In the absence, a answer, in the absence of the Korle Wulomo, a regent is installed as family head. Thus, the testimony of the plaintiffs, despite their reluctance to concede was to the effect that in Korlewe, it is the Wulomo who is the head of family. This confirms the position of the defendants that a substantive office of head of family, independent of the Wulomo, does not exist in Korlewe. I find therefore that the Wulomo is the head of family in Korlewe. The dispute, however, is on the issue of who fills the void of the absence of the Wulomo. In other words, between the death of a Wulomo and the installation of a successor, who acts? The plaintiffs contend a regent is appointed, and in the instant case, the first plaintiff was appointed such regent. The defendants, on the contrary, says the Ga-Mashie is the customary or traditional person who acts in such actions. It will be necessary at this stage to resolve the issue of the role of Ga-Mashie in Korlewe. So now Kasiani. We understandably, because the plaintiffs dispute the customary role assigned to the Ga-Mashie in Korlewe affairs, they led only scanty evidence in respect of the issue. First plaintiff, however, stated, without giving details, that there was a dispute between the Ga-Mashie and Korlewe and that the dispute has not been resolved. This position is to justify plaintiff's argument of the necessity for appointment of an elder to oversee the affairs of the household following the death of the Wulomo. For the defendants, whatever dispute there was between the Ga-Mashie and the Korlewe was resolved, and that the Ga-Mashie resumed its traditional role as regent. The defendants also regrettably did not specify when exactly that dispute was resolved. Does the Ga-Mashie act in the absence of the Wulomo as contended by the defendants, or does the family appoint an elder to act in the absence of the Wulomo as stated by the plaintiff? Since it was the plaintiffs who asserted that the regent or acting head of family is appointed to manage the affairs of the Korlewe, they carry the evidential burden of proving that fact. This they could do by naming the various Wulomo and the heads who were appointed to manage the family on their demise. This they failed to do in their evidence in chief and also under cross examination. So akamake keji nyeke keji Korle Wulomo be je Ga-Mashie ni yue na jian Shimon ato we kuricho ni le take over nye cho awo Korle Wulomo ne gbofe ke ame meni ato ni ame ba ya me na jian ka tabi ami ni ato Wulomo konklo ame nye ni ame chon na kajiboni ko teke. Now, under cross examination, the fourth plaintiff was asked to can you give the names of the various Korle Wulomo from the time of Niadu the first and the various heads of family who nominated them with their elders? I can give the names of the Wulomo, but not the various heads of family. I put it to you, apart from first plaintiff, Korlewe has never had a head of family. There have been many heads of family. It sounds misconceivable that of the many alleged previous heads of family, the plaintiffs were unable to name even one. It is equally worth noting that they could not call a single witness from the family to corroborate their version. So achono keke na bi amesande amenye amecho komepu ake Korle Wulomo ne egbo atome ne ye na awon mene wekunupa amenya amecho kwa agbene wa amenya ameche mokokra ni mo ba yi odase ake nakan noko yemi. The defendant say fete nyebua defendant say the way na me answer ne case ne botuwe. The defendants, on the other hand, called Ayite Ayi from the public records and archives, who testified as DW1, defense witness 1. He tendered Exhibit 3, a report of an inquiry into the alleged distillment of Takiya boy Ga-Mashie in 1921. Exhibit 3, as an ancient document, speaks eloquently of some of the customary and traditional practices in contention in the instant case. I shall refer to relevant portions of the report. At page 13 of the report, C.W. Velman found the following. It is relevant to mention that the Ga-Mashie holds a special position in the Ga constitution, being it as it were the linguist of the Mancheme. In case of the vacancies of the paramount stool, the Ga-Mashie acts as Ga-Mashie. Wow, really? Right. So, that is true. Yeah, so there you have it. So, I confirm here. Ga-Mashie. So, Ga-Mashie ya wale wa ya gan. Ga-Mashie. Okay, in case of the vacancies of the paramount stool, the Ga-Mashie acts as Ga-Mashie. He also looks after the Korle fetish house when the post of Korle Wulomo is vacant. So, money ache from the public records department, the defense section eba answer. Lele eba je commission of inquiry woloni afe ni eyo dasi ake lele keji Korle Wulomo be Ga-Mashie ji money ekwo ese. This extract from Exhibit 3 corroborates the assertion of the defendants. I find therefore on the evidence that in the absence of the Wulomo, it is the Ga-Mashie who acts as Korle Wulomo. So onagawa kasenoko. Yeah, so ke Korle Wulomo be I tell you, any na Korle we me ame kusumi the way ne yo jugba ade. Especially when you like means as well, what lene can be in ojugba like my age group So this was really interesting reading it. Meaning ya nuchumo ni ichu nuchumo mlam ni tashi ni nkalefe. So mene no juno ni wofi oni. Obaka ne ke ashayeko ni eba speak on the issue ke agbene wogme. It's 29 pages. She wakalefe. Now, following this finding, it would be necessary to interrogate the validity of the first plaintiff's claim to have been appointed head of family. It is true that the first plaintiff merely asserted without giving particulars of the meeting that appointed him the convener of the meeting or the elders and principal members present. He relied on Exhibit A as the authority for his appointment. Learned counsel for the defendants cited that the authority of Abubakar versus Ambrandu 1963 Ghana Law Review 456 to submit based on holding one of that decision that the right of removing the head of family from office is vested in the principal members of the family, and the act of the majority will be binding upon the rest only where notice of the meeting was given to all sectional heads. Consequently, counsel argued that in the instant case, since it was the youth and not the principal elders who appointed the first plaintiff, then the appointment of the first plaintiff as head of family, even if true, is not binding on the family. The parties agreed that at a point in time, there was a dispute between the Ga-Mashie and the Korle. The cause of the dispute was, however, not disclosed. It would appear that while the dispute persisted, the Ga-Mashie would not resume its traditional caretaker role. Accordingly, the necessity for the appointment of somebody to fill the gap became evident. The first plaintiff, a principal member of the Onomroko Korle, was appointed by the youth for the purpose. The defendant were equivocal on the status of first plaintiff. While first defendant conceded that first plaintiff was one of the principal elders of Onomroko Korle, the third defendant contended first plaintiff does not hold any position in Korle. This is how the first defendant testified to the issue under cross-examination. Do you know that following the death of Nuumo Okai II, the then Korle Wulomo, the youth of Onomroko, appointed the first plaintiff as acting head of Onomroko? That is not true. I suggest to you the reason why the youth appointed first plaintiff as acting head was to oversee the burial of the late Aite Koblan and the installation of a new Korle Wulomo, first plaintiff. First plaintiff was just appointed an elder to oversee the burial and installation of the Wulomo, but he showed no respect to us and left us unceremoniously. So echono gadabi atole woko nu papo keke awole keke ne dumonani afe Wulomo yala. I'm persuaded on the evidence to all that in view of the impasse between the family and the Ga-Mashie, first plaintiff was appointed by the youth to oversee the burial and funeral of the late Wulomo. Although the plaintiffs do not lead any evidence as to why it was the youth and not the principal members and elders that appointed the first plaintiff, the facts show that the defendants approved of the appointment, even if tacitly. From defendants' evidence, first plaintiff acted as head of family, at least up to the time that allegedly up to the time he allegedly disrespected the family and left unceremoniously. Challenged to prove the alleged disrespect shown by first plaintiff, third defendant said admitting, I'm sorry. So in 9 punctuation so you buy ni can you can have on punctuation me poyemi. I guarantee can get trouble. No punctuations whatsoever. So in any period yo, in any comma yo, in na no go. Me it is doubtful whether this is sufficient ground to dispute the leadership role assigned to the first plaintiff in the family. At any rate, there is no evidence that the appointment was subsequently revoked. So jeje ya womiake lele atole wokuyicho jeni atole pe ake ebakwe ni afu Wulomo ni egboe. It is trite that the appointment of a head of family is the prerogative of the principal members of the family at a meeting convened for that purpose. That evidence is lacking in the instant case. My understanding of the evidence is that while the dispute with the Ga-Mashie persisted, there was the need to appoint one elder from the family, not as a substantive head of family, but as a leader or primus inter pares to manage the affairs of the family, pending the installation of a Wulomo. So Jajan Chonohele, Susumomiele, ni be ye Ga-Mashie at the time. Ke wekuma te alo koli Wulomo te alo wekuma te at the time. It's an awo mukunde nye ni afemini ni akweni afe yala. It was for that purpose that the first plaintiff was appointed by the youth. It is important, therefore, to see the appointment of the first plaintiff not in the normal sense of appointing a customary head of family to fill a substantive office. In this case, it was for the limited purpose of addressing an emergency. I am certain it was in the same vein that the first defendant pleaded that he was the head of Korle, proud to the installation of the Wulomo, knowing too well there is no head of family in Korle other than the Wulomo, as contended by them. In these circumstances, I am prepared to accept as a fact that while the dispute with the Ga-Mashie persisted, first plaintiff was appointed as a caretaker or leader of the family. The fact that he designates himself head of family is a mere misnomer. From the foregoing analysis, I hold that the customary requirements for the appointment of a head of family, as stated in Abaka versus Ambruka Supra, are inapplicable to the facts of this case. The plaintiffs did not establish the status of the third, fifth, and sixth plaintiffs beyond the averment that they assist first plaintiff to perform his duties. Since the first plaintiff stated that other plaintiffs hold positions in the family, they should have provided further evidence to substantiate their positions. They should have provided further evidence as to what specific positions they hold in the family. In the face of defendants challenging that some of the plaintiffs are unaware of this suit and may not have approved of it, the evidence offered by the plaintiffs as to the capacity of the other plaintiffs is rather unsatisfactory. So I'm a plaintiff say lenche me come lawsuit tell lenche na kete me come ni fita me ni so ko amensu e podi enche am lenche am lesani e ko anu kwale ni wo ejawe ku mi ye de drama am no pe wa ye I'm not therefore prepared to support the plaintiff's position that by merely assisting him in the performance of his duties, the other plaintiffs are automatically principal members of the family. Yeah, just because I'm a wabo no chuo no try get be boko be to wele ame wokunu but they got attached in decide. I will next deal with the issue of whether or not the position of Korle Wulomo rotates between three families. In the Onomroko Korle way, the plaintiffs pleaded in paragraph 3 of their statement of claim that the position of Korle Wulomo by custom rotates between three families in the Onomroko Korle way. The defendants denied this averment in paragraph 7 of the amended statement of defense. It is tried law that he who asserts must prove. The onus was therefore on plaintiffs to prove with sufficient and credible evidence. It is unclear whether the plaintiffs intended to abandon their position on this issue. This is because neither did the first or fourth plaintiff who testified on their behalf offer any evidence on the issue in their evidence in chief. Yet, it was only after they had offered sufficient and credible evidence on the issue that the burden will shift to the defendants to disprove the claim. And learned counsel for the plaintiffs did not address the court on this issue. The scanty evidence plaintiffs adduced on the issue was put to the defendants when they were under cross-examination. Now, biane whether lelake Korle Wulomo shian ete jinoni aweli okejomi a rotate okeje bi e ba ya no jinoni jeje handle obiane je ko enya like jeje awo answer ke lele ke Korle Wulomo be gbese mancheji moni iyonajia ni Korle Wulomo ke wala mi eleji wekufe icho ona bonicho answer woni bi ekumo na to le ne kwa na fun. So some of the questions have been answered biane answer question as to whether answer question as to whether Korle Wulomo ka ba to hia yete atoye mi alo hia komepe alo weku kome na wo ga hia abete. That is the question. First defendant was cross-examined as follows. I suggest to you there are 3 houses from which a Wulomo is chosen. A answer. I know of only one house. Question. I suggest to you the 3 houses are Odai Ntowe, Aya Pekowe, and Adu We. Not true. I suggest to you Wulomo rotates within 3 houses. Not true. Aite Kobla was from Aduwe. I don't know. I was very young when he was elected. I suggest to you a successor would come from Odai Ntowe. Not correct. The plaintiffs should have testified to the succession of Wulomo and the houses they come from on a rotational basis when defendants denied that Aite Kobla II was from Adu We. Plaintiffs offered no proof that he was from Adu We. Instead, in the circumstances of this case, a more credible evidence would have been for plaintiffs to show the house from which 3 predecessor Wulomo to Aite Kobla II came. It is highly unsatisfactory in the absence of any background evidence to allege that Aite Kobla's successor would have come from Odai Ntowe. At any rate, not having offered any evidence themselves to be interrogated in cross-examination, the plaintiff do not expect the defendants' denials under cross-examination to be taken as evidence establishing their position on the issue. Interestingly, the plaintiffs did not establish by any shred of evidence to which of the 3 houses they themselves belong to. So jejeke nyenkake ayeshan ete ye Korle we nika to Wulomo atoye hia eten na mi enyo hia eten na mi shi nyele nche nye bata hia nyele nche nye chon hia eten no ni mi ni nyete nye di nche nyele nche nye chon but be to eko they failed to prove that the office of Korle Wulomo rotates among 3 houses. On the evidence, I hold that the Wulomo is chosen from any eligible male from the Korle way. So I'm a failing number prove I can Korle Wulomo. Shia ni a selector ke jomi. No, as far as neke judge ne is concerned, Korle we shia komeni ni numfenu ni esa aka atole Korle Wulomo. Now, issues D and F will be considered together. Won't be now shortly. In Keba can won't be now any the important parts say won't be now manu won't be now no. Issue D is whether or not, apart from the 4th and 6th defendant, the rest of the defendants hold any positions in the Onomroko Korle. And issue F is whether or not the 7th defendant is customarily qualified to be installed as Korle Wulomo. Ke answer ne ke issue number F ne Ga-Mashie rest ni woba me ona boni nchon ka gbe na Ga-Mashie ni woba me ka answer whether Nuumo Okai qualify your Ga-Mashie ni woba me. So be an jeje na le find this you know they can buy can only jeje ba answer ye jeme. It was established by evidence, and both parties agreed that to be Wulomo, the person must of necessity come from Korle and must also trace his lineage through the male line. No keji abatobo Korle Wulomo esake oje Korle ni esani ochese ni esake eje Korle. The defendant thus carry the evidential list burden of adducing sufficient and credible evidence to establish that the 7th defendant father is from Korle. So achono kwake biana mena sana me prove ake lele Nuumo Okai Korle ji eni eje no woni esake atole Wulomo. Now, in paragraph 2 of the amended statement of claim, the plaintiffs pleaded that the defendants are also members of the said family but hold no positions. The averment alone releases burden on the defendants to prove that they belong to the family. There was no obligation on the defendants to prove their membership of the Onomroko Korle family in view of the plaintiff's own averment. What they had to establish was the positions they held in the family, if any. In respect of the 7th defendant, since plaintiffs averred without exception that the defendants were from the family, what the 7th defendant needed to establish was his lineage through a male within the family. In this evidence in chief, the first plaintiff testified to the defendants as follows. So Judge Nchono Kwake Wokuyi che anifita Nuumo Okai here. Him me anifita ke yemi anifita le here. Mokomeje plaintiff say jeme ni eyo dasi ake amele ame mokomeje remind you fourth plaintiff be bakake ame wokumeji amele e bakake mokomi anifita here echebi ni oribishishi. So jeje ke na kan jeme le be I think aka answer mo because mo friend mo hele ake mokome me na cheji me so ame jeje me she just aka me be positions. So if anything there is an positions na me hold or ye Korle we no juno ni ameje na. Now when it comes to the 7th defendant, niji wache Nuumo Okai esanile enye ne chonke lele eche se jino nije Korle we. Now come over here. First plaintiff niji money ni ayi anan le examination me get come. I know first to 6 defendants. They do not hold any positions in my family. The 7th defendant, Papo Anan, is known to me. He is not a member of my family. He comes from Sempe. The fourth plaintiff's denial of the defendant's origin was more emphatic. He testified on oath as follows. I know defendants. They do not hail from Onomroko way. They hail from Sempe. So between Ameyenyo Benyana, Ame plaintiff number 1 in le meneme, Ame Jebiemo, Shame all DNA position, 7 defendant tele unlele, leje Sempe, fourth plaintiff fourth plaintiff wale ame kula, ame fe ame je Sempe, wale ame. So naga ame plaintiff selenche, ame Sandia Machi, now both way. From the very onset, there appears a serious contradiction in the plaintiff's position. There you go. So I may not make a sunny a tail and chenke. I'm a sunny a bear come. However, having pleaded that all the defendants are members of his family, it is contradictory to testify on oath that the 7th defendant is not a member of his family. Again, having stated in evidence in chief that 1st to 6th defendants hold no positions in the family, the same plaintiffs set down issue D for determination, impliedly conceding that 4th and 6th defendants hold positions in the family. First plaintiff stated on the oath that 4th defendant is the Korle Wayo fetish priestess. Once again, so 4th defendant there. Yeah, defendant number 4, leji Korle Wayo. If you're 10 age, Korle we. Anya wo moko kejo ekonklo ne ba yoko e ba chon Korle Wayo. Anya wo le na kan. Enye fine le mi bisane nye kam. And lives in the Onomroko Korle Jenny atole Wayo keke we shi Korle we jame yo. Le Korle we Wayo jame no yo. He also said 6th defendant was appointed the Korle priestess 30 years ago and lives in the family house as of right. So le Korle Wayo at the time and I take out atole 30 years ago ni still a shame ni nyangaga ame fitanye wokumai. So for 30 years, now, a determination of issue D is thus limited to the status of the 1st, 2nd, 3rd, 5th, and 7th defendant. The positions of all defendants except the 5th were pleaded in paragraph 5 of the amended statement of defense. 1st defendant was the head of Korle prior to the installation of the Wulomo. The 2nd defendant is the Ga-Mashie of Korle. So I'm a position said no fair na chon. 3rd defendant, the kingmaker of Korle or Agbache. The 4th defendant, now deceased, and whose position is not disputed by plaintiff, was the Korle Wayo. So Korle Wayo we jame ninya asu ame fanke nyele ame ewoku ami. Hey! Manga dwanege. The position of the 6th defendant, which is also not challenged by plaintiffs, is the principal fetish priestess of Korle. So and the 7th defendant is the current Wulomo. So once again, DNA defendants, I'm a statement of claim now, I'm a file, I may identify Nuumo Okai as the current Wulomo. On oath, the 1st defendant stated that the 5th defendant is the Sakumo Wulomo. The 2nd and 3rd defendants are also said to be the Ga-Mashie and Agbache respectively of the Korle. The 3rd defendant led evidence to the fact that the father Tetekwe as the then Agbache or kingmaker and stood the last Wulomo, Nuumo Kobla II, and that he himself, the 3rd defendant, lived with the last Wulomo in the Onomroko house for over 30 years. He further testified that the 2nd defendant succeeded his father, James Ashong Ayite, as Ga-Mashie. Plaintiffs, on the contrary, deny the existence of Ga-Mashie and Agbache. In respect of the Agbache title, the plaintiffs suggest defendants may be confusing the position of Agbache to Agbache. It is worth mentioning at this stage that names and titles are featured commonly in the suit. Some of these names and titles have been spelled with slight variations by the parties. In this connection, it has to be said that references to Jesse, Jasi, Jase, and Ga-Mashie refer to one and the same office. I will hereafter adopt Ga-Mashie to refer to that office. As noted earlier in the judgment, the defendant tendered Exhibit 3, an ancient document from the archives to prove the fact of the existence of the title Jase within the Korle. At page 8 of the exhibit can be found the following. The Onomroko Korle, the Onomroko people of the Ga-Mashie quarter. So once again, any established Onomroko, they are of the Ga-Mashie quarter, who are said to be represented by Afutu Kote and 3 elders who signed the charges, are the members of the Korle, the servants of the Korle fetish, saying be Jesse or Jasi, so to speak, of the Korle priest. First plaintiff consistently denied the existence of Ga-Mashie at Korle under cross-examination on July 16, 2004. The following transpired: that Tetekwe Molai was at one time the Ga-Mashie of Korle. A answer: that is not true. He was made a caretaker. Okay. So at the time of Tetekwe Molai, who was the Ga-Mashie of Korle? Answer: at Korle, we do not install Ga-Mashie. The Ga-Mashie is only at place where there is a chief. I put it to you that Korle has a Ga-Mashie. Again, no. And the Ga-Mashie is the same as Saint Hebi. There is no Ga-Mashie at Korle. Ga-Mashie is the same as Saint Hebi. Okay. Despite their consistent denial, first plaintiff's last answer, weighed against the contents of Exhibit 3, shows either a confusion of thought or lack of knowledge of, of the history of Korle, or a deliberate attempt to mislead the court. In Exhibit 3, Ga-Mashie and Saint-Hebi are used interchangeably. So Saint-Hebi, Ga-Mashie, Korle, they are one and the same. See page 14 and 21. The assertion by first plaintiff with Ga-Mashie is the same as Saint-Hebi. The assertion that Ga-Mashie as Saint-Hebi is an indirect concession that the title of Ga-Mashie exists in Korle because it is the same as Saint-Hebi. Exhibit 3 is an ancient document over 90 years and produced from proper custody. In Kessie versus Nami 1981, Ghana Legal Review 445, the point was made that where documents are of such antiquity, they generally prove themselves. Again, wherever there was in existence a written document and conflicting oral evidence, the practice of the court was to lean favorably towards the documentary evidence, especially if it was authentic and the oral evidence was conflicting. See Yokwa versus Dua 1992 to 1993, Ghana Bar Review 278 CA. When the third defendant testified that the second defendant's father was Ga-Mashie and the second defendant was at the direction of the Ga-Mashie Manche elected by his family to succeed his father, he was not challenged on this material fact. Brobe J, as he then was in the case of Hammond versus Moi and ANR 1991, Ghana Law Review 89, applying the principle, stated that the Supreme Court in Ford versus Ayurebi 1966, Ghana Law Review 627, stated at page 91 of the report that the law is quite well settled that where a party makes an averment and that averment is not denied, no issue is joined and no evidence need be laid on that averment. Similarly, when a party has given evidence of a material fact and is not cross-examined upon it, he need not call further evidence of the fact. The learned judge also stated on the same page that where a party makes an averment and his opponent fails to cross-examine on it, the opponent will be deemed to have acknowledged sub silentio that averment by failure to cross-examine. On the evidence offered in this case, I find that the title of Ga-Mashie exists in Korle and that the second defendant was elected to succeed his late father as Ga-Mashie prior to the disputed installation of 7 defendants as Wulomo. Plaintiffs rely on similar arguments to deny the position of Agbache in the family and consequently dispute the third defendant's claim to that title. The third defendant, who described himself as Agbache, said it was the same as the kingmaker and that he performs the installment of the Wulomo. The third defendant rectified that at the customary request of the Ga-Mashie, he was appointed by the family to fill the vacancy created by the death of his father, Tetekwe. According to him, it was his late father, Ga-Mashie, or kingmaker, that installed the last Wulomo, Nuumo Okai II. The first plaintiff stated he has not heard of the title of Ga-Mashie. The following is how he confronted the issue in cross-examination. Korle as an Ga-Mashie. Answer. The Ga-Mashie is the one who makes a canopy for the funeral rites of the Korle. So let Ga-Mashie okay. Ga-Mashie is the same as the kingmaker of Korle. Answer. Not true. It was the kingmaker who appointed Ni Aite Koblan II as Wulomo. Again, not true. In cross-examination of the first defendant, however, plaintiffs suggested that defendants were referring to was rather Ga-Mashie. I don't like Ga-Mashie. Since both the first and fourth plaintiff did not take part in the installation of Nuumo Aite Koblan II, they would not be in any strong position to challenge the assertion by the defendant that Tetekwe as Ga-Mashie or kingmaker installed the last Wulomo Aite Koblan II. That conclusion, however, did not only absolve defendants from providing the existence of the title Ga-Mashie. Under cross-examination, first plaintiff stated that Ga-Mashie is the one who make a canopy for the funeral rites of the Wulomo. He denied that office holder is the same as the kingmaker. In cross-examination of the third defendant, this is what transpired. You testified in your evidence in chief that apart from Ga-Mashie and Ga-Mashie, there is an Ga-Mashie. Yes, it is Ga-Mashie or Ga-Mashie. It is Ga-Mashie. I suggest to you there is no position at Korle known as Ga-Mashie. There is, and he is Osiahini in tree. I suggest to you what is known at Korle is Ga-Mashie. We don't have Ga-Mashie. The Ga-Mashie is the head of the fetish priestesses. Oh, the Ga-Mashie is the head of the fetish priestesses. A answer, it get not true. It get Korle. I'm a Ga-Mashie. She I'm a Ga-Mashie. The Ga-Mashie is invited to the installation of any new Korle Wulomo appointed by the family. A answer, it get not true. From the foregoing evidence, the contradiction in the plaintiff's position is clear. After initially stating the Ga-Mashie is a canopy maker, they later stated she is the head of the fetish priestess. He gets Sunday now make a year. I'm make a Sunday against Nuumo Okai. Shona Bena me shwa me yansi ye kote. Nuumo Okai, the legitimate Korle Wulomo. Nuumo Okai. Mene make a Sunday against Nuumo Okai ye shia me. Come on me ye shina ma shwe ye kote. I'm a Sanjina me UFA emo. Jeje wofe ne chafon. Emo inge mo. The plaintiff also failed to establish the former or current holdings of the Ga-Mashie, of the Ga-Mashie office they refer to. When third defendant testified that his deceased father was the Ga-Mashie who installed Nuumo Aite Koblan II, that piece of evidence was not challenged in cross-examination. I'm a fair mistake here. The strict rule that where the evidence led by a party on a material fact and is not challenged by his position in cross-examination, and the opponent does not tender evidence to the contrary, the facts deposed in that evidence are deemed to have been submitted by the opponents and must be accepted by the trial court. Now, since the first and fourth plaintiffs admitted they did not take part in the installation of Ni Aite Koblan, they will not be in a position to challenge the defendant's evidence that the third defendant's father, as Ga-Mashie, installed the last Wulomo. In the light of the inconsistent and unconvincing evidence offered by the plaintiffs against the evidence of the defendants, the court is persuaded to accept the version of the defendants and to find that the title Ga-Mashie exists in Korle and that the third defendant is the current holder of that office. Once again, defense say Nuumo Okai ke we be nibi ni akete jeje ame nibi na me UFN jeje here wo me jeje here wo me jeje ama me tashi na asu wa me sha me mu jeje he nibi na me yu awo me ni me kesane ete because of amale ka kutumpo e wo ame sanji efe momo no ame male me ne ka neke ni jeje tashi na egbo fe to ne na ge nye me ni kesane e bo amo nye sanji efe tile no many basiwe mo ame ya no kwale Nuumo Okai the legitimate Korle Wulomo. Having deposed of the status of the second and third defendants and the position of the fourth and sixth defendant having been concealed by the plaintiffs, it is only left for those on the first and fifth plaintiffs to be determined. Although paragraph 5 of the amendment statement of defense omitted to the fifth defendant, the evidence of her status was supplied in the first defendant's evidence in chief. When on 27 April 2025, he testified that the fifth defendant was the Sakumo Wulomo. The plaintiffs did not dispute the status of fifth defendant as Sakumo Wulomo. Indeed, the only time the first plaintiff mentioned fifth defendant in his evidence was when he asserted under cross-examination that Sakumo Wulomo and Naya Wulomo sanctioned the seven defendants' installation out of ignorance. This assertion, independent of the customary role assigned to the office, is an admission that that office exists in the family. Plaintiffs did not name any office holder of that officer other than the fifth defender. I find, therefore, on the evidence that the fifth defendant is a Sakumo Wulomo. All right, I'm quite amaya any any answer Nuumo Okai no ye koni mangmo ona bede sejege now. So number 7, whether Nuumo Okai is ake atole Wulomo. So bobi etwe is the seventh defendant customarily qualified to be installed as Korle Wulomo. To disqualify the seventh defendant, it must be proved he is not from Korle or is not the son of a male member of Korle. The plaintiff sought to prove this by alleging he is from Sempe by virtue of his name, Pakpo. The defendants countered by saying the name Pakpo is from Sempe, but that it was borrowed. I accept that explanation offered by the defendants that the name Pakpo was borrowed from Sempe and customarily conferred on the seventh defendant. Plaintiffs admitted that Sempe people can also borrow Korle names. I find that as a fact that seventh defendant is the son of first defendant and is therefore from Korle. I further find that by the fact that he is I further find that by that fact he is customarily qualified to be installed Korle Wulomo. Agbena. Onim sisi ama kan eja meko. Ega komo. Is the seventh defendant customarily qualified to be installed as Korle Wulomo? To disqualify the seventh defendant, it must be proved he is not from Korle or is not the son of a male member of Korle. The plaintiff sought to prove this by alleging he is from Sempe by virtue of his name Pakpo. The defendants countered by saying the name Pakpo is from Sempe, but that it was borrowed. I accept that explanation offered by the defendants that the name Pakpo was borrowed from Sempe and customarily conferred on the seventh defendant. Plaintiffs admitted that Sempe people can also borrow Korle names. I find as a fact that seventh defendant is the son of first defendant and is therefore from Korle. I further find that by that fact he is certainly qualified to be installed Korle Wulomo. Abena. Inka bene abu. So court we agree ake. Nuumo Okai lele echeje Korle echeseje Korle and by that virtue alone he is qualified. Nesani eye Korle Wulomo. Now, from the nation bona. It was established by the evidence that, barring any impasse, it is the Ga-Mashie who presides over these matters. The defendants have argued that the dispute between the family and the Ga-Mashie was resolved, and he resumed his traditional role in the appointment of the 7th defendant. So once again, Ga-Mashie at the time, Sani ani no mi ekete ke kole we bi ate a solve na kan Sani ni egmebe ni ekpene ni ato Nuumo Okai ake kole Wulomo. Now, amakane na agbe mabo no nu jeje ewu ame chafon no ni jeje beni jeje kegbe na ni mashibo video ese jeke bona so amakane mabo na agbe eke ingmo eke ote. Now, the plaintiffs have never lived in the house and do not assert that any of them is one the 3 heads permitted to live there. They also talk of chairs, tables, and money without providing any details. They also failed to confront the defendants while they were in the box. Indeed, the matters relating to these two issues border on criminality, and it is doubtful plaintiffs would have countenance. It is doubtful plaintiff would have countenanced such an attack by high talks without lodging a formal complaint with police. I find the allegations unproven and dismiss them. So nibi na me yuake ni ake wako like a tax, wako like a langard teba na ba jame na dwasenji ke nibi ni alone bi efe jeje ke ehe ameye ejake na ke no, it's a criminal act. So efia me na akpake ni telashi na ke langards ba na ba jonye na dwanye shi na dwanye shika na afiti onye senji ke nibi ni nye report ye ha police. Jeje ke ame report ye ha police. Me you know ni jeje ke. In conclusion, the plaintiff's claim is dismissed. Judgment is entered for the defendants. So ni amekesani te kote awo achafo ni kote agree ake Nuumo Okai e qualify yo ake ebaye Korle Wulomo. So ganame the legitimate Korle Wulomo legi Nuumo Okai. It can report in she about 5 or 6 pages. No mele aye she and Sandeke send I mean nibi na make ajuju ke nibi ona bonincho. But the relevant portion say I think no ken abue. Kamo ko bibu ake na moji the legitimate Korle Wulomo Nuumo Okai legi mo no na. Ngbeji ni tete obobi ashon. Oyibla don wa. Twa ni o manyafo no. Bye bye.
Yeah baba. Yeah baba. It's neat. Them say you want to chop my